All right, future barristers, listen up. If you are deep in prep for the Queensland Bar exam, this is one session you absolutely cannot afford to skip. We are about to do a masterclass on one of the most fundamental tools in your litigation arsenal, Rule 149 of the Uniform Civil Procedure Rules. You know, if you get this right, you're building your case on solid rock. Get it wrong, well, let's just make sure that doesn't happen. Ready? Let's dive in.
So, here's our game plan for today. We're going to start with the why behind pleadings, the foundation. Then we'll get into the absolute core duty, pleading material facts. After that, we'll talk about the cardinal sin of the surprise attack, cover the technical must-dos for pleading statutes and relief, untangle the exception for pleading conclusions of law, and then we'll wrap it all up by talking about the art of drafting with purpose. Let's get to it.
Okay, first things first. Why do we even have all these rules about pleadings? Well, think of a pleading as the architectural blueprint for your entire case. It is the absolute bedrock of civil litigation, and it's designed to uphold one principle above all else: procedural fairness.
And honestly, it all boils down to this one golden rule from the High Court. This is the quote to remember. The entire point of a pleading is to let your opponent know with total clarity the exact case they have to answer. This isn't about setting traps or playing clever games. It's about making sure it's a fair fight where everyone knows what the real issues are right from the get-go.
So how does that big principle of fairness actually work in practice? Well, it leads us directly to your single most important duty when you're drafting a pleading, and that's governed by Rule 149, Subrule 1, Paragraph B.
And there it is, Rule 149, Subrule 1, Paragraph B. Let that sink in. A pleading must contain a statement of all the material facts. Now, material is the key word here. What does it mean? It means essential. Ask yourself this: if I took this fact out, would my cause of action collapse? If the answer is yes, then guess what? It's a material fact, and it has to be in your pleading.
Now, the knock-on effects of this rule are huge. You are strictly, and I mean strictly, confined to the case that you plead. This isn't a guideline, it's a hard boundary. Your pleading literally defines the entire battlefield. It tells the judge what issues they need to decide, it limits the scope of disclosure, and it dictates what evidence you're even allowed to call at the trial. It's all about that procedural fairness. The only, and I mean only, exception is when both sides basically agree to throw the pleadings out and fight the case on a completely different basis, which is incredibly rare and super risky.
So, if pleading all your material facts is the core duty, then springing a surprise on your opponent is the cardinal sin. And this brings us to the next critical piece of the puzzle. Rule 149, Subrule 1, Paragraph C.
For your exams, burn this one into your brain. Rule 149, Subrule 1, Paragraph C. This is the anti-ambush rule. Its whole purpose is to stop one side from getting blindsided at trial with some argument or fact they had no clue was coming and so had no fair chance to prepare for.
But what do we actually mean by surprise in the legal sense? Well, the court in Chan v. Gondenwater gave us a really clear definition. It's not just something unexpected happening. I mean, trials are full of that. It's an issue of fairness. It's when an unexpected turn happens that a reasonable party just couldn't have prepared for because the pleading gave them zero warning that it was even an issue.
And you can see how this plays out in the cases. So Chan gives us the modern test. Pretty straightforward. Nelson tells us that, hey, it's probably a good idea to plead things that are a mix of fact and law, just to be safe and avoid any claims of surprise. But then you have Lewis v. Lewis, and this one is a major cautionary tale. In that case, the judge actually let the evidence in, even though it caused surprise, but made it crystal clear that this was a rare exception. You cannot rely on that happening. It's playing with fire, and you risk having your key evidence thrown out.
Okay, let's move on to a couple of technical rules. These are really simple, but they are absolutely non-negotiable. If you get these wrong, you're just asking for a headache. We're looking at Rule 149, Subrule 1, Paragraphs D and E.
Right? 2 simple steps. First, under Rule 149, Subrule 1, Paragraph D, you have to spell out exactly what relief you're asking the court for. And here's a pro tip from the case of Meredith v. Palmcam. If you're claiming damages, the particulars belong in the body of your pleading, not just tacked on in the prayer for relief at the end. Second, under Rule 149, Subrule 1, Paragraph E, if your case relies on a statute, any statute, you must name the specific section you're relying on. No ifs, ands, or buts.
And here is a massive exam tip for you. Messing up Rule 149, Subrule 1, Paragraph E can be completely fatal to that part of your case. Seriously, as the court made clear in Cam v. Bell Pacific Holdings, if you don't plead the specific statutory provision, you might not be allowed to rely on it at all.
It's such a simple rule, but it has potentially devastating consequences. Now, I'm sure you've had it drilled into your head. Plead facts, not law. And look, that's generally true. But like with so many things in law, there is a crucial exception, and it's found in Rule 149, Subrule 2.
So here's the deal. Under Rule 149, Subrule 2, you can actually plead a conclusion of law, something like the defendant was negligent or the contract was breached. But, and it's a big but, you can only do it if you also plead the material facts that support that conclusion. The legal conclusion is basically useless without its factual foundation. It's a two-part test, and you have to nail both parts.
Let's make this really practical. You can't just plead the defendant was vicariously liable. The court in Concrete Verkumner was clear on that. You have to also plead how they were liable. For instance, that an employee was acting in the course of their employment when they did X. Same goes for agency, as we saw in Dominus for a Daydream. You can't just say they were an agent. You have to plead the facts that created the agency. The what is your legal conclusion, the how is your material facts. You absolutely need both.
Okay, so we've covered the core rules. Let's finish up by talking about the actual art of drafting. Because it's not just about ticking boxes and following rules. It's about communicating with absolute clarity and precision, and always keeping the spirit of the UCPR in mind. Look, let's be blunt. The courts are losing their patience with lazy, ambiguous drafting. As the judge in St. Clair v. Tintala pointed out, phrases like and/or just create confusion. They don't clarify anything. Same with including but not limited to. It's an open-ended phrase that fails to properly define the issues. Just be direct, be precise. Your job is to make things clear, not to create a fog.
And really, that brings us full circle. Because every single rule we've talked about today, every technicality, every principle, it all serves one overarching purpose. It's the North Star of all civil procedure. Rule 5, Subrule 1. To facilitate the just and speedy resolution of the real issues with a minimum of expense.
I want to leave you with this really powerful quote from SGIC v. Sharp because I think it just perfectly captures the modern approach. The days of winning or losing on a clever pleading point, divorced from the actual justice of the case, are over. Pleadings are a vital tool for achieving justice, but they are not the endgame. The courts want substance over form. Your job is to use your pleadings to help them get to a just result.
So, as you head into your exams and, more importantly, as you head into your careers, ask yourself this question every single time you draft a pleading. Is this document a clear, fair, and precise roadmap to justice? Or is it a confusing, ambiguous, procedural dead end? The answer to that question will define the kind of advocate you become. Good luck.